This is some information if you are interested in a later time checking out either my YouTube channel where you'll find videos like the one we just showed. If you're not part of our Facebook group, Texas Landlords, you can also follow this QR code there. But my contact information again is right here. And at this point, I'd like to open up for questions that might be out there. Potential problems. The HOA might have a problem with that if they consider it a structure. And so if you need to get special permission from the HOA, that's step one. So I wouldn't authorize anything unless I know either A, there are no HOA limitations, or B, if there is an HOA, that I have permission from the HOA to do this. In terms of, what the shed will do to improve the value of the property, if anything, depending on where it is, it might devalue the property by destroying an area of grass. So that's a risk. If that destruction of grass is minimal or essentially doesn't mean anything to the property owner, then maybe this is a way to curry some good favor. But does it make sense to do this for free? Maybe what the landlord does is says, absolutely, I'll allow it, but because of the loss that I'm going to incur, I'm going to increase the rent, or I'm going to modify the lease in this other way. So it shouldn't, number one, you have to calculate, how is this going to harm me potentially? And then number two, why does this make sense? There may be no rent increase, but maybe he uses this as the impetus to modify the term and say, you know what, I'm going to lock you in right now, not speculatively in the future, right? So if that's the way he's thinking, I would do the modification presently. If we're just talking about Harris County, I talked about the 16 justice courts in Harris County. Harris County is broken up into 8 precincts. And each precinct has 2 places, place 1, place 2, just like you've explained. And so it does not matter within the precinct whether you go to 1 or 2. In fact, in certain precincts, if you ask me, I'm going to say avoid place 1 at all cost, or avoid place 2 because that judge is not as favorable to you as you would like. And so this happens a lot. The other thing that could happen is, and this happened this year, I think in maybe 3 or 4 courts in Harris County where judges retire. And so now there's a brand new judge that you know nothing about. And so that's a roll of the dice. In a certain precinct right now, we've got a situation where that's happened, and cases come to us in those precincts, and so we're walking in kind of blind and just showing up and kind of figuring out that court. Other courts, they've been there as long as I've been in practice, and so I know that judge very, very well, and I can predict for my client what's likely going to go on based on the facts of their case. But because the courts are constantly, judges retire or judges get voted out, it's good to ask first. Because it's not static, and in terms of making the choice, it could be the one closest to you is the bad one, and so it's worth an ask. So there's a couple of ways you could do this. Harris County in particular offers, so they have this website that we use where you punch in an address and it'll tell you what precinct you're in, and based on that, from our experience within that precinct, we'll make a determination. So there are certain precincts where we absolutely do not go left. We're going to go right. And I don't mean politically speaking. You know what? I don't have it committed to memory. If you shoot me an email, I can send it to you. It's just a link that the county offers. But another simple way is to say, I think it's this one, or this is the one I'm familiar with. I'm going to call them and have them do the check for me. You may say, I'd like to speak to the eviction department. I'm interested in filing an eviction. I just want to make sure my property is within the precinct. And they may do the search for you and say, oop, no, you are calling precinct 1, but you need to file in precinct 4, or something like that. So yes, there is a county website for Harris County that can be used, but certainly a helpful clerk, they're not always 100% helpful, but a helpful clerk can answer that question for you. Yeah, which is better than filing and then waiting and see, because you're going to lose your filing fee. You have. It's total per month. Yes. And so you are maxed either at 10% if you have a building of more than 4 units, so your big apartment complexes, 10%, 12% if it's 4 units or fewer, duplexes, single families, smaller apartment buildings, that sort of thing. Now, it is possible to prove that your actual damages exceed that. Not likely, and I wouldn't toy with those percentages. If it's a single family home, stick to 12% per month and collect it within the first 7 days, right? You got to wait till day 4, 3%, 3%, 3%, 3%. You're within your 7 days and you've collected the maximum. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. So let's talk about that. You are not a finance company. This is not a finance deal. So this is not credit where interest. Owner finance, that's different. And if you have a rent to own or owner finance deal, that's not a lease. And those are not subject to eviction, not until there's a foreclosure. And a lot of people come to me and say, yeah, I want to get rid of this tenant. And I look and say, well, your document clearly says buyer and seller. Well, yeah, but it's a rent to own. They own it. You cannot evict an owner. Different kind of talk that we have with them, right? So then now we got to do a foreclosure, and then once you have title, then they become a tenant at sufferance and yada yada. That's a whole different thing. But as far as late fees, you got to wait to the 4th day or later, and you're capped by statute. Single family home, 12%. Apartment, 5 units or more, 10%. And I recommend get it all within the first 7 days. So I no longer see rent relief coming where the state is paying. There is still, and there always has been, relief from private entities. So certain privately funded organizations are still offering rent relief, but the state-sponsored rent relief is, as far as I can tell, essentially dried up and no longer a thing. Could you still enter into an agreement and abate a case holding out for that rent? You can. I don't suggest it. If a tenant is eligible for it, and maybe you are eligible for it, I would still say secure a judgment, because why not get your judgment and then check to see if there's, rent help available. And if there is, you haven't abated the finding for a judgment. You've got your judgment in your back pocket, which you can exercise anytime. And if it turns out that there is rent relief and you want it, then you can just tear up your judgment, file a release of judgment or whatever, and then take the money. But there's less and less of that money out there, and I don't see it as the windfall that it was 2 years ago. A couple years ago, in the middle of the pandemic, there was so much money going around. I was telling landlords, go get it, because the courts aren't allowing evictions anyway. So if this is the agenda they're pushing, at least get paid. Don't lose money. Yeah, it's a state matter, and certainly certain states lean politically more favorably toward tenants. Texas is not a state that does that. Although some landlords will tell me, oh, Texas is so pro-tenant, I can't. Well, ever been to California? Ever been to New York? It's rough over there, and I hear people, I've got members of my YouTube channel from those states who constantly tell me, life's different out here. And yes, there is a push. I've seen that President Biden is pushing for more tenant rights and some kind of they call it different things, but talking about it and actually getting it done are two different things. That stuff is still technically applicable to federally owned or federally controlled property. So I want to talk about the CARES Act, the USA CARES Act. If you have property that is federally backed, you got Fannie Mae, Freddie Mac loans, you may be subject to a 30-day notice to vacate from the USA CARES Act that was signed in March of 2020. It's a provision that was so poorly written, I've seen dozens of attorneys fighting over it in Facebook groups as to whether or not it actually still applies. Some more liberal counties in Texas say it does. Harris County, as far as I have seen, for the most part, does not. That doesn't mean that some judge can't, on his or her own agenda, say, you know what, I kind of like the sound of this. It's questionable enough for me to say, yeah, it does apply. And I'm going to say that it applies. And so where I counsel clients is if you have a federally backed mortgage on a rental property, you have to consider it as a possibility. You can make the call as to whether or not you want to give 30 days or 3 days. But I've seen it go clear through courts and it never gets mentioned. Like I said, most cases don't get challenged. But I've also seen it stall. I've also seen it cause delay or cause cases to be dismissed. So it's a risk that a landlord can take. In Texas, it's so wishy-washy because the law itself was poorly drafted. And we know that speedy legislation often is terrible legislation, right? Yes. So yes, notice defects. Part of my little Lego presentation talked a little bit about defects that are in notices. Nothing gets landlords in more trouble with a contested eviction like notice, right? It's not usually the ledger because even if the ledger is imprecise, there's usually $1, right? And that's all you have to prove. $1 remains unpaid or was paid 1 day late. And as long as you can prove that, an imprecise ledger can be figured out. And sometimes the judge just says, look, I'm not even gonna count that month because you can't prove it to me clearly, but I can count these for sure because even the tenant says they didn't pay these months. So that's how those cases are resolved. But notice cannot be fixed. The notice has to be proper prior to filing. And so you're gonna clean up a lot of these notice issues by sending it by regular and certified mail. If you remember nothing else, send your notice to vacate, regular and certified mail, because delivery is part of it. The other one, and I came across this issue just this week from a landlord who came to my office. She won on the justice court level. She's headed to appeal. So she's going to county, and that's why she came into my office. I need help. And said, well, I'm happy to help you, but your notice to vacate isn't actually a notice to vacate. Yours is a notice of termination. And there is a difference. When you say your lease will end 30 days from today, that's not what a notice to vacate is. A notice to vacate is, I am presently terminating your lease, get out in 3 days or I will evict you. You see the subtle difference? One is, you're still good for 30 days. There is no breach. The other one is, you are presently in breach, get out in 3 days. Or get out in 30 days, whatever. And because the notice didn't say get out, it said your lease will end, it's not technically a notice to vacate. Now, that doesn't mean there aren't clever ways to get around that. And we will use clever ways to get around that. And you know, fingers crossed, we're gonna get to a good resolution for our landlord, you know? But I can't guarantee anything. And when I can see that there's a problem, I'm up front with my client and say, look, this is a problem that I have no control over, right? If it comes out, it comes out. But if we can help it, we will. And we've got strategies for doing that. But yeah, many problems are caused by improper delivery of a notice or the improper substance in a notice. Chapter 24 of the Texas Property Code is pretty clear, and I've got tons of videos on notice at my YouTube channel if you're interested. Numerous videos dealing specifically with that topic. So you had a follow-up, Ray? That's a great question, because I have a lot of landlords who come to me and say, I don't even know why I'm doing this. I already have a judgment from the Justice Court? You don't. By virtue of that appeal, the judgment is gone. The only right that remained was the right to possession because of the document that the tenant signed that says, I hereby promise that during the pendency of this appeal, I will pay rent into the court registry. And if I don't, I'm subject to an immediate writ of possession. The judgment is gone. That promise is made post-judgment. So it survives, but there is no judgment. And so if you're owed unpaid rent up until the date of their possession, right? If you're owed unpaid rent or attorney fees or court costs, and you want them in a judgment, you have to go down to the county court and get that judgment. No judgment presently exists. You have nothing to abstract. So my recommendation is always to follow the case downtown and get that judgment, because of the possibility when you abstract it that down the line they're going to pay. And at the very least, future landlords should know this is a bad tenant, avoid this tenant. So the question is, do you hire an attorney to do that? I don't know how complicated it's going to be to go probably win another default judgment. And unless you are an LLC or something, and if you are an entity and you are the owner, then you can go and win a default judgment. You can't send your property manager on something like that. So that's where it gets a little complicated. But if you're the owner of an entity, yeah, you can show up, and if the judge says you have insufficient representation, is a trustee available to also appear? I would say get both of you guys on the call, and you can probably prove up your damages. Right, and if you're saying, look, I have no intention of abstracting this judgment, what you could do preemptively is contact the court and say, non-suited. I don't want this, I'm not interested in the judgment, and I don't want them to show up and say whatever, just non-suit it. So you could just cut it right off at the knees. There will be zero record of an eviction on that tenant, but if possession is all you really wanted anyway, you're done. If you want to do an owner finance deal, I encourage it. And so you can do an owner finance deal, but don't think that you have a tenant. An owner finance deal, you are giving title in exchange for a lien, just like a bank. And you're being held to the same rules that banks are. And if you currently have a mortgage on that property, you have all sorts of disclosures that are owed to that buyer under Chapter 5 that can get you into so much trouble, you lose your property. So, is this something that I recommend you do? Kind of being familiar with it? Absolutely not. Because I've seen clients get into all sorts of trouble because they have no idea the yearly disclosures that are owed to the buyer while you still have a loan. You can't function like a bank or a mortgage company and not be subject to their requirements. There are protections out there for buyers that exist to prevent what have in the past been predatory lending strategies. And so because of that, even if we have no predatory intention, we still are subject to these rules. Now, rent to own, that's what's known commonly as a contract for deed. Those are also a bit messy because once the renter to own person has paid 40% of the purchase price, they are entitled to a deed and a deed of trust and a promissory note. And they can call it any time. And if you're trying to evict somebody in that situation who has been there for 8 years and has passed the 40% threshold, you're going to district court. And this is going to languish for years if it's contested, right? Because they've got equity now in the property. And Chapter 5 protects that equity. And so you do not have a conventional tenant. And because of that, I don't recommend those deals. I would prefer that you start off with a deed of trust, and a promissory note, which upon default, you could exercise with a foreclosure and then be done with them, as opposed to going through a title dispute in the district court, which could go on for years. I know this because I handle these kinds of cases. They're messy, and hard and expensive, and expensive. I had. So the state of Texas doesn't use the term notice of eviction or eviction notice in the property code. But what I think you mean is a notice to vacate. It is the notice that is required in order to file for eviction. Without a notice, you may not have a notice of termination. You may not have a notice of default, but you must have a notice to vacate in order to proceed with an eviction. So some people refer to it as an eviction notice or notice of eviction. Keep the original, send the tenant a copy. Our notices feature the tracking number on the letter itself. That way, when we show the court, we show the little green slip that comes from the green card, we show the letter, and then we show the envelope that came right back to us. They all have the same number, in case it's ever questioned. Who do we send it to? And then, of course, our receipt also shows, and we sent it regular mail. And our letter says, delivered by regular and certified U.S. mail. If you are typing it out and hand signing it, keep the ink original. Send a copy to the tenant, right? That way you can prove the actual original to the court if they say, that's not the version I got, this is the version I sent, and here's the ink signed original. If you get anything returned to you, it's best evidence unopened. Right, I've had clients come and they open it and it's like, well, that's no longer good evidence to prove proper delivery, but it might be evidence to prove mailing. You can't prove what was inside the envelope because you just opened it to the air. So yes, if you get it back, leave it sealed. Yes. So I use a 3 strikes policy, right? So if in a given year term, a tenant has 3 strikes, that's when you can consider whether or not you next want to issue a notice to vacate. Now, you also want to think of just how egregious these strikes are. 3 is not a magic number that courts say, well, it's 3, I have to issue the eviction now, but it might be a rule of thumb, right? So if they had an unauthorized occupant and an unauthorized pet, and then they were late with their rent, those 3 strikes might be enough, especially if they happen in a short time frame, to get rid of them. But if, for example, they didn't properly maintain the yard and you want them to water every week, and you go and you can tell, hey, you didn't water last week, and they're like, oh, I forgot, notice. And then later you go by and they left the trash can out front, and like, ooh, that's bad, notice. Because these are things that they could probably demonstrate to the court. Look, 90% of the time I'm on this. He caught me on a time when I didn't do it. Yes, it's technically a breach, but is it one that might result in me losing possession? I'm going to tell you the ticky-tack stuff never are, right? So you want to give notice, but if you think you're going to pull off an eviction for something that, number 1, was remedied, and number 2, is not that big a deal, it's just not going to happen. It's not going to happen. The big ones are unauthorized pets, unauthorized occupants, and non-payment of rent, right? And late payment of rent. If somebody is habitually paying late, you can give notice of that, and that's usually a pretty good basis for eviction. Very last question. There are 2 kinds of animals that are not pets: emotional support animals and service animals. In the state of Texas, only a dog can be a certified service animal for the blind. But emotional support animals could be all sorts of things. A goldfish, a beaver, an ostrich. We've literally seen these emotional support ostriches, and the question is, at what point does it go beyond a reasonable accommodation, right? Because you can't have an emotional support rhinoceros. That doesn't happen, right? Even though you say, I'm so emotionally attached to Riney. And it's like, no, that doesn't make sense. So you would have to make a reasonable accommodation for an emotional support animal. It's usually a cat or a dog. But to prove that they are an emotional support animal, you have the right to ask for medical documentation from a state of Texas practitioner that the tenant has this medical need and that this pet or this animal serves that function. If they don't have both of those, you can question it and potentially deny them. That's it in a nutshell. There's so much more that goes into this talk, and I do have multiple videos on this topic, and there is a ton of content out there about it, but it is sometimes a bit confusing. The key is, can they establish it with medical records from a Texas practitioner, not something they got offline from, Joey Pet Doctor or Emotional Ernie. It's got to be a Texas medical practitioner. And I think I'm done.
Yes, let's give him a hand. Thank you, Ernie,
Absolutely.
for sharing your valuable time. I will tell you firsthand, I'm not a member of a lot of Facebook groups, but I'm a member of his. You have such good engagement and conversations going on there, and occasionally he weighs in, and I look for the times that you weigh in.
Yeah, and the truth is, I can't, weigh in on all of them. I've got staff that kind of chimes in for me sometimes, but the landlords that are there give such good advice. Like, I agree. I'll just give it a like and say, yeah, that's good.